Check 1, 2. Good morning. All right, we are going to call to order this committee meeting of the Judiciary Committee for today, Monday, March 23rd, 2006, and then we're going to stand in recess, and we will join you hopefully shortly. All right.
it's full protection. If all these guys come in and you raise it, yeah, it's kind of great, but it's a mess.
What is wrong with this?
So we'll see. Let's see. My problem this time, I don't have an ask this year. I don't really have an ask, right? We've kind of gotten everything we wanted, right?
So is there a chance that they're in the fucking meeting?
We are going to reconvene the Judiciary Committee meeting for Monday, March 23rd, 2026. Thanks for everybody's patience as we get through caucus and hopefully have a productive first JF meeting here today. Seeing no remarks from my co-chair, get the door closed over there, and then we will turn to our agenda. We'll start on item number 1, which is Senate Bill number 89, an act updating prison rape elimination standards. The motion will be a JF.
So moved. Second.
Motion from Senator Winfield and a second from Senator Kissel. I will, before we get into discussion on this, I will entertain a motion to amend Senate Bill 89 to, in lines 3 and in line 64, insert the words executive branch after the word any. So that's inserting the word executive branch after the word any in lines 3 and line 64.
So moved.
Second.
Motion from Senator Winfield, second from Representative Fishbein. Let me entertain discussion on the amendment. Is there discussion on the amendment? Seeing none, let me try your minds. All those in favor of the amendment, please signify by saying aye.
Aye.
Any opposed to the amendment? Seeing none, the amendment is adopted. And I will now entertain discussion on the underlying bill. Representative Dubitsky.
Mr. Chair, I
thank
just
you.
wanted to let you know that people on the Zoom are having trouble hearing you. If you wouldn't mind just speaking a little more into the microphone. Thank you.
All right. Is there discussion on the bill? Is there discussion on the bill? Seeing none, maybe Representative Fishbein for motion, please.
Yes, thank you, Mr. Chairman. Mr. Chairman, I make a motion to create a consent calendar, and we move SB 89, an act updating prison rape elimination standards to said consent calendar.
Is there objection to placing this item on consent? Is there objection to placing item number 1 on consent? Seeing none, that is so ordered. Next, we'll turn to Senate Bill number 90, an act revising and consolidating the hate crimes statutes. The motion will be a JF. Motion from Senator Winfield, second from Senator Kissel. Next, I will entertain a motion to amend Senate Bill number 90 to add a new section 45, which I believe the text of which has been circulated to the committee, but essentially the amendment would have the Connecticut Sentencing Commission, in consultation with the State Hate Crime Advisory Council, do a review of the laws of this state concerning offenses that are hate crimes and the penalties associated therewith. Before I explain the basis for that, I will see if there's a motion for that amendment.
Second.
Motion from Senator Winfield on the written amendment, second from Representative Fishbein. The intent of this amendment is, this hate crime bill has been before us twice now. While I'm prepared to support it moving out today, because I certainly understand the intent and the purpose of trying to consolidate our hate crime statutes, I would think it's appropriate that when we consolidate, we look at the gradations that we charge. You know, our hate crimes have been scattered across the general statutes, and as I look at it, there doesn't seem to be a whole lot of consistency as to why something may be a D misdemeanor and something else might be a D felony as opposed to an A misdemeanor. And I think it is probably past time that somebody say, we've got 44 sections of the general statute that revolve around hate crimes. Let's make sure they are consistent with each other and that we're actually charging the proper or imposing the proper penalty for particular crimes. And so I think the body who is best able to do that is the Sentencing Commission, because all the stakeholders are already at the table, and that is the purpose of the Sentencing Commission, is to look at why we charge certain things for certain offenses. And certainly they can rely upon the advice and the guidance from the Hate Crime Advisory Council in doing that study. Further discussion on the amendment. Further discussion on the amendment. If not, let me try your minds. All those in favor of the amendment, please signify by saying aye.
Aye.
Any opposed? The ayes have it. The amendment is adopted. Discussion on the substance of the bill. Is there discussion on the substance of the bill as amended? If not, Madam Administrator, if you could, Representative O'Day?
I'm good. I was just gonna make a comment if it was gonna be going on the consent calendar. So I have no comments.
All right, the bill is not going on consent, so we will have a roll call vote. Madam Administrator, please call the roll.
Roll call vote on Senate Bill 92 JF, to the floor with Amendment A. Winfield,
Winfield, in the affirmative.
Staffstrom.
Yes.
Flexer. Gadkar Wilcox.
Yes.
Fazino.
Vizino votes yes.
Kissel.
Yes.
Fishbein.
Yes.
Blumenthal. Brown.
Brown votes yes.
Oh, thank you. Cabrera.
Yes.
Callahan.
Callahan, yes.
Ciccarella. DiCaprio.
DeGarmo votes yes.
Thank you. Dillon. Delaney.
Delaney, yes.
Doucette.
Yes.
Dubitsky.
Yes.
Elliott. Gaston.
Senator Gaston votes yes.
Gilchrist. Godfrey. Howard.
Yes.
Jacobson.
Yes.
Johnson. Khan. Lamarck Muir.
Yes.
Lesser. Marr. Miller. O'Day.
Day voting no to flag.
Osborne. Pavlik D'Amato.
Pavlik D'Amato votes yes.
Perillo. Quinn. Rahman. Roberts. Bertigliano.
Yes.
Sims. Beach.
Yes.
Walker. Wilson.
Thank you. We will hold the votes open until 4 p.m. All right. Moving on to Senate Bill number 91, an act enhancing the investigative authority of the Inspector General and establishing protected areas. The motion will be at JFS. It is LCO number 3510. Is there a motion?
So moved. Second.
Motion from Senator Winfield, second from Senator Kissel. Is there discussion on this bill? Senator Winfield? Oh, Representative Fishbein?
Thank you, Mr. Chairman. You know, obviously, immigration, which this is one of the bills that we have regarding this, is a hot button issue, not only here in Connecticut, but across the country. You know, during the public hearing, I was very happy to engage with individuals that had come to us regarding their concerns. You know, last night I happened to go back and watch a lot of that testimony in anticipation of today. There was a particular exchange that day where a member of the public came to us and claimed that our Supreme Court on September 8th had, by a 6-3 decision, authorized that ICE could round up and harass individuals based upon their perceived ethnicity. I pushed back, but I didn't know the case in particular. I wasn't educated on that date as to that particular case. Last night I happened to pull that case, and that's the case of Christy Nome versus Perdomo. And my review of that case has to do with whether or not a stay should issue from a district court. There was language where individuals of the Supreme Court opined on their position on certain aspects. The decision to issue the stay was apparently a 6-3. But the only member of the U.S. Supreme Court that wrote in the majority, there's a concurring opinion on the decision, was Justice Kavanaugh. And Justice Kavanaugh expressly on page 5, and that's part of the problem here, is cases are issued, media interprets the cases, and then that's what people digest as being the fact. Justice Kavanaugh on page 5 says, to be clear, apparent ethnicity alone cannot furnish reasonable suspicion. And that's reasonable suspicion of somebody being here illegally. It's a lower standard than probable cause. And essentially what he said was that that combined with other factors may allow for that standard, but certainly did not say what was represented to us on that day. The representations to us that day were very troubling to me, because as we take an extension of that, certainly the decision doesn't say anything about rounding up and harassing. But whether or not it is lawful for mere perceived ethnicity to be authorized is actually an open question, because the U.S. Supreme Court has not decided whether or not they're going to take cert on this. The status of the case is if they take cert, then the stay will be in place while they deal with the particular issues in the Perdomo case. If they don't take cert, the stay goes away, and the decision of the district court would be the law of the land, or at least of that district. So, you know, I appreciate the exchange, the debate, and the opportunity to actually look at what one justice of the U.S. Supreme Court had to say, not 6 justices. So, thank you, Mr. Speaker, Mr. Chairman.
Senator Kissel.
Thank you very much, Chairman Staffstrom. I'm supporting this bill because I do believe that there's certain areas within the state of Connecticut where anyone, even an illegal immigrant, undocumented alien, however you want to classify it, should feel safe and protected. We did pass a bill recently that would expand those protections to courthouses. I had no problem with the courthouses. I did vote against that bill ultimately in the end because it extended it to parking areas and walkways. And I just think that sometimes the protections get so far afield that they make the work of immigrations and customs enforcement almost impossible. But I think there are some areas that, especially areas of worship, school grounds, where people should feel safe. And that it would actually work a real disservice not only to the undocumented aliens, but to law-abiding citizens to have immigration and customs enforcement take action in those areas. It could just disrupt what should be an area where things can move forward. So on this bill, and I believe this is a governor's bill, there should be some safe spaces, and so I will support this one. There's another bill that we'll get to in a little bit. I believe it came out of the Senate Democrats, and it's sort of like Goldilocks, right? Some chairs are too hard, some are too soft. I'll be voting no on that one to flag it because I think it just goes too far. So I understand that a lot of folks in Connecticut have concerns regarding the policies of ICE, the Immigrations and Customs Enforcement. They have not done particularly well in certain areas of our country. I certainly share my constituents' concern and frankly, their anger at customs enforcement killing people that are protesting in various areas of our country. And immediate upon those activities, I would hope that charges would be brought and investigations made as to whether unlawful use of force was utilized. But that being the case, Immigrations and Customs Enforcement do have an important job. People should not be here illegally. And for those illegal immigrants or undocumented aliens that are criminals and that have well-documented criminal histories or are outside the law above and beyond the immigration laws, having committed murders or assaults or other things against anyone, whether they're a regular citizen in our country, a non-citizen, a visitor, whomever. I think in those instances, getting those folks out of the community and into proper hands is a heightened concern. And so there's varying degrees of culpability on one side, but there's lawful means to exercise that on the other. We've seen this recently, again, with Immigrations and Customs Enforcement, but we've seen it over the decades with any kind of law enforcement in general. And occasionally they go beyond what authority we as a free people have given them, and they have to be reined back. I get it. And at the same time, we all should be able to live and work and play and raise a family and everything else that we do in our free society. And so it's a balance. And so I'll be supporting this moving forward on one side of the ledger, voting no to flag the other bill in a few minutes on the other side of the ledger. And hopefully by the time this issue gets before the House and the Senate here in our state legislature, we're not a national legislature, just a state legislature, we can come to a compromise across party lines. Maybe we won't, but at least at this point like to strive in that direction. So for those reasons, I'm supporting the bill. Thank you, Mr. Chair.
Thank you. Representative Bitsky.
Thank you, Mr. Chairman. Mr. Chairman, people who are here illegally should be sent home. Illegal aliens should not be here. That's why they're illegal. The federal authorities are going to pick them up. They're going to pick them up somewhere. Where? I asked this question in the public hearing. Where should they be picked up? They're going to get picked up. So by this bill, we are saying certain places where they should not be picked up. By the Trust Act and the Trust Act 2, the amendment to the Trust Act, we have also put certain places off limits where they could be picked up. So where should they be picked up? We have made it very difficult for federal authorities to fulfill their statutory obligation that was enacted by Congress and signed by a president before this one, requiring that the federal authorities pick these people up and send them home. So where should they do that? Okay, so they shouldn't do it at schools or courthouses. So on the street, on the way to the school or the courthouse? The best and safest place would be in prison, when the person is already incarcerated. The feds could send 1 or 2 people to safely go pick them up, put them into federal custody, send them home. That would be the smart way to do it. That would be the safe way to do it. That would be the way that would best serve the people of this state. But in its infinite wisdom, this legislature has decided that prisons are not a good place for federal authorities to take custody of illegal aliens. So what are they doing? They're picking them up on the streets. That's not safe. We are forcing them into places where they need to have lots of agents, armed agents, because they have no idea what they're going to encounter. So the smartest thing for us to do is to eliminate the Trust Act and to allow our law enforcement to cooperate with ICE. So when ICE wants to come and pick somebody up, they can do it safely while the person is already in custody. But instead, we force them out. We force them to track these people down and arrest them in their house, on the street, where other people could be involved or could be picked up. What this bill does is it expands that to other areas. So there's now other places that ICE can't pick these people up. So again, I ask, so where should they pick them up? They're going to pick them up. It's the law. They are required by law to take these people and deport them. They're going to do that. And, you know, they're going to do it the easy way or the hard way. We should make it safe and easy. For the people of our state, we should make it safe and easy for the federal government to fulfill its statutory obligations. We shouldn't make it difficult and dangerous, which is what this bill does. Thank you.
Further questions or comments on this? Representative O'Day?
Thank you, Mr. Chair. And I do appreciate, as I understand the changes here to the underlying bill, I just want to mention, you know, I was part of the group back in 2012 with then Chair Jerry Fox and later with then Representative Tong in trying to come up with a balancing act between getting criminals off the street, illegal immigrants, serious criminals, because as my, you know, and I do agree with, you know, the comments that have been made, you know, we seem to be trying to protect criminals more than we are trying to protect victims. And so I guess my question, Mr. Chair, in the change, I was working off of LCO 534. I understand this is LCO 3510, and 3510 lines 19 through 20 appear to be similar to the LCO 534 lines 53 through 55, where we take out the sentence about United States Marshal or Deputy Marshal and any special agent of the federal government authorized to enforce the provisions of Title 21 of the U.S. Code, and we replace that with any federal law enforcement officer as defined by 18 U.S.C. 115C1 or 34 U.S.C. 503015. And Mr. Chair, my question is that specific change was to address specifically what?
Representative Day, my understanding is this change is being made to narrow the definition of peace officer from the original bill based on some of the comments and content from the public hearing.
Thank you. And so in other words, we're focusing in, eliminating some definitions and being specific as to that U.S. code. What specifically, what individuals are we removing and what are we focusing in on if that's what's being done? Through you, Mr. Chair.
Senator Whitfield.
Representative, I can read you the section referenced in order to explain what the specific reference means. So in 18 U.S.C. 115 C1, where there is a definition for law enforcement officer, it defines it as any officer, agent, or employee of the United States authorized by law or by government agency to engage in or supervise prevention, detection, investigation, or prosecution of any violation of federal criminal law. If you give me a second, I'll pull up the other reference. I think what we're trying to do is be specific as to which agents we're talking about. But I will pull it up just so that I can read that for you as well.
No, thank you, Mr. Chair. I certainly don't mean you. So we are eliminating marshals, deputy marshals, special agents, and replacing that with the specific, as I understand it's the immigration, the ICE officers. Is that a fair summary?
Yeah, that is my understanding, but if you want, I can read the other definition so that you can have them in combination.
That would be great. Thank you.
Okay. And so when you read 34 U.S.C. 503015, it has the term federal law enforcement officer there, wherein it defines what that is. It means a federal employee who has statutory authority to make arrests or apprehensions, who is authorized by the agency of the employee to carry firearms, whose duties primarily are engagement in or supervision, prevention, detection, investigation, or prosecution, or the incarceration of any person for any violation of federal law. I think we were trying to be specific about the types of federal officers, as I said, and deal with folks inside the prisons that we weren't trying to deal with.
Thank you very much, Mr. Chair. And then taking a look at lines 64 through 65 of LCO 3510, that specifically takes away the Inspector General from investigating federal officers that would otherwise be captured, if you will, or associated with the investigation. Would that be fair to say?
Those lines 64 and 65 exempt them for those investigations related to the purpose of that portion of the bill, yes.
And that's because we're relying on the federal government to be doing that investigation, and we are not allowed or don't have jurisdiction over those federal authorities for that investigation. Is that fair to say? I don't mean to be misleading.
No,
What?
if I could, Mr. Chair, I think there's two provisions under existing law. Our Inspector General really engages in a few different types of investigations. First, they engage in investigations where there is a use of deadly force in our state. Under this language, as well as the bill we're going to look at next, which is Senate Bill 397, the Inspector General will be the one charged with investigating use of deadly force instances in the state, even if it's a federal law enforcement officer. What the change in line 64 through 65, as I understand it, was related to if there was a death within the federal prison in Connecticut, that we would not have the Inspector General investigating that death within the federal prison, whereas under current law, if there's a death in a state prison, then the Inspector General does investigate those types of instances.
Thank you, Mr. Chair. That helps me understanding the change. I appreciate it.
Yeah, I believe it was actually a concern that Representative Callahan, among maybe others, rightly raised at the public hearing, and our intent was to clear up that ambiguity.
Thank you, Mr. Chair. Look, I'm going to be voting no on this. One of the reasons why I don't think we've had the trouble with what we saw in Minnesota was because we had created these laws previously so that our law enforcement would cooperate with federal enforcement officers to get violent criminals off our streets. And we were doing that. We weren't having, violent criminals released into the general population, if you will, for law-abiding citizens we have a reasonable expectation that violent criminals will be prosecuted and not turned over to federal authorities if they're here illegally. And I think Connecticut was doing a better job in coordinating with federal authorities to make sure that doesn't happen. So we didn't see the problems we saw in Minnesota because Minnesota was not, as I understand it, again, I'm not a Minnesota resident or obviously legislator, but based on my understanding, they weren't following their own laws. And then I blame both sides. But we don't have that problem in Connecticut. So I'm not sure what problem we're trying to fix. But I'm looking forward to listening to the debate, and I do appreciate the good chairs responding to my questions and helping me understand. I'm sorry I did not see this LCO before a few minutes ago, so thank you for the indulgence.
No problem. Thank you for the questions, Representative Day. Further questions or comments, Representative Callahan?
Thank you, Mr. Chair, and I do appreciate the change you just mentioned. I'm looking at the latest LCO Section 3, and in lines 220 through 224, we're talking about parking lots and other areas that are adjacent to buildings. And that section goes further and talks about other protected areas. I'm wondering how the state can pass a law like this and tell a federal law enforcement officer they can't go to a parking lot or parking garage. Wouldn't the federal supremacy clause make them ignore this anyway?
Short answer, no.
I think our federal authorities in Connecticut will beg to differ, but the two previous speakers that talked about the Trust Act, and I've said this in committee before, so I'll be brief, is when we used to do this, I did this for decades with INS and ICE. We worked closely with these agencies to pick up offenders that perhaps were here illegally, committed additional crimes, and they're always picked up in a controlled environment like a courthouse, a police station, DOC facility, a probation office, a parole office, and the Trust Act has driven that enforcement into the streets, which happened in Minnesota, and they're starting to go back on those laws now and agree to more cooperation. So it seems to me like the Trust Act has created the situation where enforcement has gone into the streets. And now we keep trying to redefine what the Trust Act will do rather than just allow our state agencies to cooperate and have these people picked up in controlled environments instead of in public, because that seems that's where most of the complaints are by the public and where most of the issues occur. So I just think we continue to try and stop leaks here, but it's the wrong way to go, and I'll be voting no.
Thank you, Representative Callahan. I appreciate that, and I get what you're saying about a controlled environment, but I just would be remiss if I didn't mention, I think Section 3 refers to a host of locations that at least I would not consider to be controlled environments. It specifically talks about preschools, health clinics, churches, school bus stops, domestic violence shelters. The list goes on, and I would submit that I don't know that having ICE conducting immigration activity in those brings safety or closure to anyone.
If I may respond, Mr. Chair,
Please.
that I certainly agree. But if those, I wouldn't want law enforcement activities in those areas either. But if we allowed them back in our controlled areas, like I mentioned, Department of Corrections, jails, things like that, and have them picked up with detainers, they certainly would be less likely to go to those areas you mentioned in Section 3.
Thank you. Further questions or comments on the bill? Further questions or comments? If not, Senator Winfield for some closing remarks.
Thank you, Mr. Chair. I appreciate all of my colleagues' comments and the thoughts of folks who I've had conversations with. If I'm listening to the conversation, one would assume that all of the folks that we are talking about who don't have legal status are some criminal that, should we not have done the policy that we've done in this state, you just easily pick them up in our prisons. That's just not the situation, both here in the state and across the nation. If you look at ICE's data, you know that that's true. And I think that should be taken into account. This is not to protect criminals. This is to make sure that we have a policy similar to what we had prior to January of 2025. And not just, some folks will refer to the administration prior to the current administration and their expansion of protected areas, but we've had protected areas for a long time. We've had a Trust Act in the state for a long time, so they've operated in combination. So in a way, we're returning to a way that we were operating. I want to say something about the Perdomo case, because I think it's important to understand. And for me, what I understand is our experiences create our reality. All of us have different experiences here. Some hew closer to other folks' experiences. My experience has been different than many of the folks who I consider colleagues and friends. And when we're talking about the Supreme Court allowing for ethnicity to be one of the factors, as Representative Fishbein said, he's correct in that. But you have to ask yourself why that's one of the factors to consider. What is it about an individual's ethnicity that is a trigger for that? Is there something inherent about an ethnicity that leads to criminality? I know a little bit about this. I lived in a city, New York, where we operated that way. And we can say all we want about what the letter of the thing does, but what it does on the ground matters as well. And what it does on the ground is terrifies people because we know where these things lead. Some of us have experienced this directly. We've experienced what racial profiling is, what profiling because of ethnicity is. And so we come here today saying we are looking to be protective, not of criminals, because the majority of folks we're talking about aren't criminals, but protective of folks. Some of the people who've been deported the most are Haitians and Jamaicans, right? We always talk about people from Latin America in the way that we think of Latin America, but they've been those folks. They don't necessarily look different than me. And so while some of the folks here never have to deal with that because they don't look like the ethnicity that It's criminal in some folks' minds. Some of us do. It's not implicating just those who don't have legal status. It also implicates those of us who were born here, who maybe for generations have been part of the armed forces of this country and the fabric of this country. It implicates everyone. And I think that's why we should be doing this bill, and it's why I will support this bill. Thank you, Mr. Chair.
Madam Administrator, please call the roll.
Roll call vote on Senate Bill 91 of JFS to the floor with LCO 3510. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Gadkar Wilcox,
Yes.
Fazino,
Fazino votes yes.
Kissel,
Yes.
Fishbein,
No?
Blumenthal, Brown,
Brown votes yes.
Yes.
Callahan,
Callahan, no.
Chicarella,
Chicarella votes no.
DiCaprio,
DiCaprio, no.
Delaney,
Delaney in the affirmative.
Dillon,
Dillon votes yes.
Doucette,
Yes.
Dubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Howard, Jacobson,
Yes.
Johnson, Khan, Lamarck Muir,
Yes.
Lesser, Marr, Miller, O'Day,
Day votes no.
Osborne, Pavlak D'Amato,
Havelock Tomato votes no.
Perillo, Quinn,
Yes.
Rahman,
Strong, yes.
Roberts, Rutigliano,
No.
Sims,
Sims in the affirmative.
Veach,
No.
Wilson,
Thank you. I'm next going to turn to item number 6 on our agenda, which is Senate Bill number 397. This is an act concerning democracy and government accountability. The motion will be a JFS. The LCO number is 3480. LCO 3480 JFS of Senate Bill number 397.
So moved.
Motion from Senator Winfield, second from Senator Gadkar Wilcox. Is there discussion on this bill beyond the discussion we had on the previous bill? Is there discussion? If not, Madam Administrator, please call the roll.
roll call vote on Senate Bill 397 to JFS to the floor with LCO 3480. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Gadkar Wilcox,
Yes.
Fazino,
Fazino votes yes.
Kissel,
No.
Fishbein,
No?
Blumenthal,
Ready?
Brown,
Brown votes yes.
Cabrera,
Yes.
Callahan,
Callahan, no.
Chicarella,
Chicarella votes no.
DiCaprio,
No.
Delaney,
Delaney yes.
Dillon,
Dillon, yes.
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Howard,
No.
Jacobson,
Yes.
Johnson, Khan, Lamarck Muir,
Yes.
Lesser, Marr, Miller, O'Day,
Day is no. Sorry. Day votes no.
thank you, Osborne, Pavlak Tomato, Perillo, Quinn, Rahman,
Yes.
Roberts, Rutigliano,
No.
Sims,
Sims in the affirmative.
Beach,
No.
Walker, Wilson,
Thank you. We'll return to item number 4, Senate Bill number 290, an act clarifying the meaning of sexual intercourse and sexual conduct. The motion is a JF.
So moved.
Motion from Senator Kissel. Is there a second?
Second.
Second from Representative Fishbein. Is there discussion on this bill? I will just know, I'm prepared to support this bill today. I know there's been quite a bit of discussion back and forth between the proponents of this bill, as well as the Public Defender's Office, I'm not sure the language before us is maybe the final form language, but I do agree that something needs to be done here, that there does need to be some sort of clarification to make it more possible to prosecute these horrific crimes. You know, I know there's some other states out there that have some different language than what we're looking at today, and I know those conversations continue, but I'm prepared to support the bill out of committee today. Senator Winfield?
Yeah, Mr. Chair, in a similar vein, I don't know that if it hadn't been represented to me that there was work ongoing, that I would be voting for this bill. I would like to see what the result of that work is. And I will say that while I think this is known, while I am comfortable trying to work with folks, should we not make progress, I will not be looking to move this bill any further. So I hope that those who are working on it can find their way to a space where we can all feel comfortable voting. But my vote today reflects only that I believe that that work is ongoing and to give the opportunity to get there. Thank you, Mr. Chair.
Further discussion or comment on this bill? Further discussion? If not, let me ask maybe for a motion on this.
Mr. Chairman.
Well, see if Representative Fishbein has a motion to make.
Mr. Chairman, I make a motion that we move item number 4, SB 290, an act clarifying the meanings of sexual intercourse and sexual contact to the consent calendar.
Let me go nice and slow. Is there any objection to placing the item on the consent calendar? Is there any objection, knowing that this is a work in progress at this point? Okay. If not, seeing no objection, then it'll be so ordered. All right. Item number 5. Senate Bill number 295, an act concerning state law protections for healthcare providers and patients related to the provision of a legally protected healthcare activity. The motion will be a JFS. The LCO number is 3529.
So moved.
Motion from Senator Winfield, second from Senator Gedkar Wilcox. Senator Kissel.
Thank you very much, Chairman Staffstrom. I'll be voting no today to flag this. It's definitely a delicate area when it comes to legislating and the policies involved here. It has to do with reproductive rights, transgender, all of that stuff. And since the Dobbs decision, and it's been percolating since Roe versus Wade, and in fact, a lot of other Supreme Court decisions, some of which originated right here in Connecticut in the 60s. But these issues are definitely sensitive to a lot of folks, especially in my neck of the woods, my district. People have very strong beliefs on all areas of this issue. And so hopefully at the end of the day, I'll be able to find a way to support this legislation. But at this point in time, I have to flag it because there are questions that are still being discussed in my district about if we here in Connecticut afford ourselves as protectors of people's rights from other states, does that somehow go against individuals' principles here in our state? And how much are we here in Connecticut going to be used as a buffer against policies that people might believe in other parts of the country? I don't know the exact answer to all of these things, and I welcome further input from my constituents regarding this. But again, I think that ever since the Dobbs decision, this whole issue has gotten much more heightened scrutiny from individuals, and therefore that's why I'll be voting no. Thank you, Mr. Chair.
Further questions or comments on this bill, Representative Dubitsky?
Thank you, Mr. Chair. This bill, as like some of the bills that we did last year, tries to hide certain conduct through euphemism. Sex change surgery is not reproductive health care services. Now, in this bill, it changes it to legally protected health care activity. Well, you know, what adults do to their own bodies, God bless them. I don't agree with it, but there's plenty of things that I do that other people don't agree with. I'll do me, you do you. No big deal. You want to hack off body parts? God bless you. But children who don't understand what is going on in the world should not be subjected to this kind of mutilation. It's baffling to me that we would allow minors to cut off their breasts, to cut off their penises, to change their very physiology when they don't have the mental capacity to make those decisions. A few days ago, we had a hearing in this very committee. We had people come in and testify over and over and over that a person's brain is not developed enough to make a decision of whether or not to commit a crime until they're 26 years old. 26! Yet, in this state, a doctor can see a child, 16-year-old boy, and the 16-year-old boy could say, "I'd like my penis cut off, please." "Sure. When do you want it done?" That's crazy. That kid can't make that decision. He's not 26 years old. He's a minor. I will therefore introduce an amendment that essentially says that no health care provider will treat any person under the age of 18 with puberty blocking medication or artificial cross-sex hormone medication or surgery, sex reassignment surgery, or gender-affirming health care services to any minor under 18 years old. The amendment is being handed out. I move for adoption.
It's a proposed amendment from Representative Dubitsky. Is there a second? Second was from Representative Pavlik-D'Amato. Is there discussion on this amendment?
I have one, thank you.
Is there discussion, Senator Winfield?
Thank you, Mr. Chair. I appreciate my colleagues putting forth the amendment. I am going to oppose the amendment. I would ask folks to join me in opposing. This is a serious conversation that I don't think we, to this point at least, have had enough of. It really has impact on lives. I will also just say, to the conversation about the adolescent brain, that conversation has always been interesting to me, the way that it functions, one way in respect to certain issues and another way in respect to other issues. But it's really a conversation about the inability of young folks to think in a higher level way in when they're making rash decisions, when they're in the middle of an emergency, when they don't have the time to do the kind of thinking that they otherwise are actually capable of. And if you were using that argument, and you were using it the way that the science would lay, you would say that in most of the types of crimes that we've been talking about with young folks, they in fact don't have the higher level governing capacity that we talk about. Given the way that this issue lays out, with the level of consultation that happens, it's a little bit different. That doesn't mean that we should be moving forward with some types of gender affirming care. That's for each individual to determine for themselves. But this issue does not work the way that it's generally laid out in this committee, and we've been talking about it for a long time, and we probably should really understand how the development of the adolescent brain actually plays into these policies. Thank you, Mr. Chair.
Further discussion or comment on the amendment? Is there further discussion or comment? Can we do a voice vote on this, or do we need to do a roll call?
Roll call, please.
Roll call has been requested. Madam Administrator, please call the roll.
A roll call vote on Amendment A for Senate Bill 295. Winfield?
Winfield in the negative.
Staffstrom?
No.
Flexer? Gadkar Wilcox?
No.
Fazino?
Fazino votes no.
Kissel?
Yes.
Fishbein?
Yes.
Blumenthal? Brown?
Brown votes no.
Cabrera?
No.
Callahan?
Callahan, yes.
Ciccarella?
Ciccarella, yes.
DiCaprio?
DiCaprio, yes.
Delaney?
Delaney no.
Dillon? Doucette?
No.
Dubitsky?
Yes.
Elliott? Gaston?
No.
Gilchrist? Godfrey? No. Howard?
Yes.
Jacobson?
Yes.
Johnson? Khan? Lamarck Muir?
No.
Lesser? Marr? Miller?
No.
O'Day?
O'Day votes yes.
Osborne?
Votes no.
Pavlik D'Amato? Yes. Perillo? Yes. Quinn?
No.
Rahman?
No.
Roberts? Vertigliano?
Yes.
Sims? Veach?
Yes.
Walker? Wilson? Jacobson?
Madam Administrator, I'd like to respectfully change my vote from the affirmative to the negative, please.
Madam Administrator, for Blumenthal votes no.
Thank you. Representative Dillon?
Dillon votes no.
Representative Gilchrist?
Representative Gilchrist votes no.
Representative Johnson? Representative O'Day?
O'Day votes yes.
Madam Administrator,
Yes, Representative.
can you repeat my vote on the amendment? I'm sorry, I thought we were on the bill.
So on the amendment, I have you marked as a yes.
Oh, thank you.
Yep.
Madam Administrator, I think you have, did you get Representative Johnson's vote on
I'm
the
trying
amendment?
to unmute her. She.
Oh, hello, Madam Clerk.
Sorry, that's me.
Apologies. There's two of us in this room. Representative Johnson votes no.
Thank you.
Excuse me, Mr. Chair.
Hold on, Representative Miller. Let's get Representative Elliott's vote, please, Madam Administrator.
Rep. Elliott votes no.
Thank you. And Senator Marr?
Senator Marr votes no.
And Senator Miller.
No, I just want to would like you to take note that some members may be having a problem getting into using the link that was given to them. So I just wanted to bring that to your attention.
Senator Flexer? Senator Flexer.
Senator Flexer, did you vote on the amendment? All right, let's take the tally, please.
So the final tally is 12 voting yea, 23 voting nay, and 6 absent.
The amendment fails. Is there further discussion on the bill? Representative Drubitsky still has the floor.
Thank you, Mr. Chairman. I'm disappointed, but not surprised. But taking our good Senate Chair's comments into consideration, he indicated that the sort of my phraseology of what he said, that young people's brains develop in different ways based on different issues. For some issues, they are old enough to make decisions. For others, they are not. Okay, I'll buy it. I didn't see any testimony or any science that says that, but for the purposes of today, I'll go along with that. Maybe maybe minors, maybe a 17-year-old kid isn't old enough to determine whether or not to commit a crime, but is old enough to determine whether they should have body parts cut off. Doesn't sound right to me, but for the purposes of today, okay. How about 12-year-olds? There is no way we can say that a 12-year-old or an 11-year-old has the mental capacity to make the decision to have her breasts cut off. There is, and be sterilized for life. An 11-year-old kid? No way. I don't care what metric you use. No 11-year-old kid in this state should have a licensed doctor perform sex change surgery on her. None. It's barbaric. It should be criminal. So I've got a bill, an amendment here that would do the same as the other one, but lower it down to 12 years old. Anybody under 12, no doctor could prescribe puberty blocking medication or perform surgery on any child under 12 years old. I ask that that be distributed. There is no way any child of that age could have the mental capacity to make that decision. And any doctor who performs such surgery on a child of that age, in my opinion, should lose his license and go to prison.
So motion, second amendment that was proposed by Representative Drubitsky. This will be Amendment B, and it was seconded by Representative Fishbein. Is there discussion on this amendment? Senator Winfield.
Thank you, Mr. Chair. Two things. I didn't think I was going to say this. I was just going to say that I would ask for opposition based on my previous set of comments. And I know that there's no intention in misrepresenting what I said, but what was repeated back wasn't what I was saying. What I was saying is the science tells us about how young folks operate within certain types of situations and the executive functions of the brain. And it is in certain types of situations where there is limited to no ability, depending on the situation, for young folks to operate in the way that we do as we get older, and executive functions function so that we can make clearer, more thoughtful, more logical decisions. That was the difference I was talking about. It wasn't that there is a difference in every situation you would have to guess, but at its core, I would urge us to reject the amendment. Thank you, Mr. Chair.
Senator Kissel.
Thank you very much, Chairman Staffstrom. I agree with this amendment. Many years ago, when I was in college, the first degree I sought was a Bachelor of Science in Education, and I attained that and ultimately did my student teaching at Coventry High School. But in the coursework, one of the things that we examined was development, and it's not what I would call brain development as is spoken of by Senator Winfield and the folks that came out last week regarding brain development not being complete until around age 26. I remember the works of a researcher called Jean Piaget, who in terms of education said that children's brains go through approximately 4 stages where the synapses and the interconnections allow conceptualization of certain things at certain stages. And the final stage was at approximately 12 years old, and that was the highest stage of conceptualization, abstract reasoning. So way back when I was studying the work of Jean Piaget and child's ability to comprehend, it wasn't just a matter of biology. It was the way the brain is wired as a child grows, and that final stage is not attained until a child hits approximately 12 years old. As this amendment contemplates a child's brain prior to that, then I would have to believe that based upon the works of someone highly respected in the field of education, Jean Piaget, that a child hasn't even have the wiring within its brain. Forget about being able to, at 26, comprehend, a scary situation and what you're going to do, and do you commit a crime, do you not commit a crime? That's a whole different area of investigation. This is just something much more fundamental, and I think that, to his credit, Representative Dubitsky has offered an amendment regarding an area that, at least based on my knowledge, is not in doubt. And for that reason, I'm happy to support the amendment. Thank you, Mr. Chair.
Further discussion on this, Representative Fishman?
Mr. Chair, if I may.
Hold on, Representative O'Day. We're going to go with the folks in the room first, and then I'll get to you. Representative Fishman?
Thank you, Mr. Chairman. Mr. Chairman, I think it's a good amendment. All through the pandemic, we kept on hearing, trust the science, trust the professionals, follow what they're recommending with regard to how to deal with this scourge that, attacked the world that we had no idea what to do with. Just last month, Mr. Chairman, the American Medical Association, the largest physicians group, said, stop this. Said you should not be doing gender-affirming care for minors. That was followed on the Plastic Surgeons Association, the week before. The American Society of Plastic Surgeons took a very similar stance. Either you trust the science or you don't. We're talking about here is kids. I learned a lot about this area last session when we had it. And we had people come to us, told us their stories. as I said, I learned a lot, and placed myself in the shoes of a youngster. I mean, even myself as a youngster, I had troubled youth. They're always looking to identify, why am I here? What am I going to do? All that stuff. It's the last time that you should be making a major decision like was before us. So either you trust the science or you don't. The experts are saying you should not be doing these things to children. And I think they're right. So thank you, Mr. Chairman.
Representative O'Day.
Thank you, Mr. Chair. And the ranking member kind of stole some of my thunder a little bit. I appreciate his comments, and I'm still trying to figure out what I want to do when I grow up. But on a serious note, he quoted the British. There's a British medical journal reports that the two major U.S. medical groups, the American Society of Plastic Surgeons and the AMA, American Medical Association, have said that you have to wait for any breast, chest, genital, or facial gender-related surgeries until at least age 19. And as the good proponent of the amendment cited, we recently heard testimony here that the brain doesn't develop for many until the age of 26. And I take the good chair's comments. I understood what he was saying, that the spur of the moment, quick decisions are more difficult for someone until they're 26. Some would argue until 60 for some of us here, but I'm working on it. But in a serious note, the science is clear. We heard a lot of testimony on this issue, and we heard about a lawsuit. New York hospital got sued and was rightly lost. And minors cannot make decisions like this. Parents should not be making decisions that are permanent for kids like this. We passed laws preventing genital mutilation based on religious grounds because of what we've heard and the horrible stories. And while some may believe at age 12, 11, or 10 that they want to be a different sex, they do not, there's no argument. They don't have the capability to make that decision. And I agree with the proponent. And I've said this before, I think I said it on the floor. What's going to change this is good lawyers suing hospitals and doctors who mutilate permanently children. I don't know how some people look at themselves mutilating a 10, 11, 12-year-old. And so I urge my colleagues to pass this amendment. We should not be doing this on children. Thank you, Mr. Chair.
Senator Winfield.
Thank you, Mr. Chair, and I appreciate my colleagues and their talking to us about the American Medical Association. To be clear, the American Medical Association came with a position on surgeries, which the American Medical Association can do, but did not opine on everything that falls under what we would call gender-affirming care. And to my point about why I have issue with this, I think that this amendment is broader than the surgeries we're talking about. And I think that if we are to make a movement here, it should be a movement not to disrespect what anyone's thinking, because I think we all have the right to put forward whatever, but a movement that is thought out more than what we are doing in this moment. So I would still urge folks to oppose this amendment. Thank you, Mr. Chair.
Representative Doucette.
Thank you, Mr. Chair. Question to the proponent of the amendment.
Please proceed.
I wonder if the proponent of the amendment could explain how this amendment is germane to the bill before us.
So, Representative Doucette, that's that's a determination that's made by the chair, not necessarily
Right,
by.
and I don't, with respect, Mr. Chair, I don't want to waste any more of the committee's time by calling a point of order on that. I wonder if the proponent wants to explain how it is germane.
If he'd like to, I mean, I will, well, let me let the proponent answer that. Go ahead, Representative Dubitsky. How is the amendment germane to the underlying bill?
Thank you, Mr. Chairman. In the S language, there is several instances where terms are defined. And the terminology for these barbaric procedures have been redefined a couple of times over the last couple of years. And in my view, they have been redefined in order to make them sound reasonable. Gender affirming care. Oh, that sounds great. But what does it mean? It means taking little children, an 11-year-old, and cutting his penis off.
Right. So, Representative Dubitsky, back to the bill. Or the question, I should say. Why is this amendment germane to the underlying bill? If we could just stay on that and not into the merits of the amendment for a second.
Mr. Chairman, point of order. If there is no point of order before the body, wouldn't the question be posed first? If the questioner has declined to challenge, otherwise, what are we doing?
Well, I think the question.
So you could call germaneness. That would be a ruling.
It is, and I'm not making a ruling on that. At this point, there has not been a point of order raised. There was a question, and I think probably a genuine one, as to whether this amendment is germane or not to the underlying bill. So I think what the questioner's point was to give the proponent of the amendment the opportunity to explain why the proponent believes the amendment is germane, and then based on the answer to that question, I could see a point of order being raised or not being raised at that point in time. I'm not making a ruling on germaneness at this point. What I am doing is allowing the proponent the opportunity to explain why he believes it's germane to potentially avoid a point of order.
I'm not aware of Masons allowing for a perfunctory action such as that before the body at this point.
I don't think it's a perfunctory action. I think it's a genuine question as to the amendment that's before us.
But procedurally, you would need to make the question, and then we're dealing with the question. But the question is not, the question as properly would be to challenge germaneness, and then we follow that route.
Yeah, I disagree. I think it's
Okay,
I think it's
that's
a valid question as to the text and the intent of the amendment. So your point of order is overruled. We will go back to Representative Dubitsky if he would like to respond to Representative Doucette's question as to why he believes the amendment is germane to the underlying bill. Sticking on the issue of germaneness, not the rationale for the bill, Representative Dubitsky.
Okay, well, the germaneness, there are instances where certain terms are redefined. Reproductive health care services, gender affirming care services. What this amendment does is it removes certain procedures from those definitions. So it is entirely germane because if we are redefining the terms, the amendment would do just that. It would remove certain procedures from those terms.
Okay. All right, thank you. Representative Doucette, you have the floor.
Thank you, Mr. Chair. Yes, no, I accept the answer. I think the good representative did answer the question, and it was, as I suspected, having to do with the terminology and the use of the terminology itself. I don't think the redefining of the terminology is in and of itself germane to the point of the bill. The point of the bill is that it is what we refer to as the SHIELD law. It has to do with conflict of laws of other states or federal law. So I do not think that the amendment, in my opinion, is germane to what we're doing here today before the bill. That being said, the good representative has a right to raise the amendment. I accept his answer. I just think folks should understand what's going on here when we have a bill before us, which is the SHIELD law, having to do with conflict of laws, why we are having this wide-ranging discussion, which frankly does not belong in this committee about these terms. So I will accept the good representative's answer, but I think it's a threshold question. That is in and of itself a reason, the germaneness question that I raised, or concern, is in and of itself a threshold reason why we should be opposing this amendment. Thank you, Mr. Chair.
Thank you. All right, Representative Fishbein, is this the second or third time?
On the amendment, this would be the second time. And
Okay.
it would
So
not
the
have
second
occurred.
time on the amendment.
It would not have occurred but for the ruling by the chair to have a debate about a motion that isn't even before the body. I will point out to the body, if you look at lines 21 through 24, it expressly says, legally protected healthcare activity means the receipt or attempted receipt by any person of reproductive healthcare services or gender-affirming healthcare services. So, while we never got to the germane question, the answer is, the language is right in there. And if the motion was actually made, we would have had the opportunity to do that. Unfortunately, we ended up debating a motion that never got to us for some reason. So, thank you, Mr. Chairman.
Thank you. Further, if not, let me just say this. I don't think
I'm sorry, Mr. Chair. I'm sorry for the second time on the amendment.
Representative O'Day for the second time on the amendment.
I didn't want to interrupt, Mr. Chair. I apologize, but I didn't want to talk after you spoke. To the good proponent of the amendment, if I may, and to address the germaneness as well, if we pass the amendment, do I understand correctly that, as the good ranking member said, lines 21 through 24, a legally protected healthcare activity would not be castration of a 12-year-old?
That was a question to Representative Dubitsky.
Yes. So right now, as I understand the law, a legally protected healthcare activity in gender-affirming care could include castration of a 12-year-old. Is that the good proponent's understanding?
Representative Dubitsky.
Yes.
Okay.
Representative O'Day.
Thank you, Mr. Chair. And to the good proponent, if we pass this amendment, that would make it not a legally protected activity to castrate a 12 or under person. Is that the intent of the proponent?
Representative Dubitsky.
Yes.
Thank you. Thank you, Mr. Chair.
All right, let me just say this, and hopefully wrapping this up. The question of whether this is or is not germane is not something that was considered before us. But what I would point out is that the underlying bill, I believe, is about the legal effect of individuals performing what is or is not legal health care services in the state of Connecticut, and potential repercussions that could come from other states for performing what is or is not legally protected health care in the state of Connecticut. I believe that is firmly within the Judiciary Committee's cognizance because it involves around legal protection and shields. What is not within our cognizance is what should or should not be authorized medical procedures in the state. I believe there's another committee that looks at that issue, and it is not this one. because as I sit here, I have found at least some research that suggests that, frankly, performing gender affirming surgery on minors already is not permissible under either Connecticut law or Connecticut regulations. And in fact, I found research that says nowhere in the country are surgeries being performed, at least based on a Harvard study, on children under the age of 18 that would involve so-called removal of organs. So while we're going to allow a vote on this, I will join my co-chair in urging my colleagues to oppose this bill, not even necessarily based on the underlying merits of it, but because I think the amendment likely goes beyond what the cognizance of this committee is, whether it is germane to the underlying bill or not. And for that reason, I'm going to be voting no on it based on a cognizance question. Madam Administrator, please call the roll.
Roll call vote on the Amendment B for Senate Bill 295. Winfield?
Winfield in the negative.
Staffstrom?
No.
Flexer? Gadkar Wilcox? Fazino? Kissel? Yes. Fishbein? Yes. Blumenthal? Brown?
Brown votes no.
Cabrera?
No.
Callahan? Ciccarella? DiCaprio? Yes. Delaney?
Delaney, no.
Dillon?
No.
Doucette?
No.
Dubitsky?
Yes.
Elliott? Gaston?
No.
Gilchrist?
Gilchrist votes no.
Godfrey? Howard?
Yes.
Jacobson?
No.
Johnson? Khan?
No.
Lamarck Muir?
No.
Lesser, no.
Miller?
Miller, no.
Marr?
Mar votes no.
O'Day?
O'Day votes yes.
Osborne? Pavlock D'Amato? Yes. Perillo? Yes. Quinn?
No.
Rahman?
No.
Roberts?
No.
Retigliano?
Yes.
Sims?
Sims, no.
Veach?
Yes.
Walker? Wilson?
Wilson votes no.
Johnson?
Representative Johnson votes no.
Thank you.
Madam Administrator, may I be heard?
Yes, Representative Osborne?
Osborne votes no.
Thank you.
KB.
Yep, Vizino?
Yep. Representative Fazino votes no.
Thank you.
And Elliott votes no as well.
Thank you.
Thank you, Madam Administrator. Blumenthal votes no.
Thank you.
And Madam Administrator, Senator Flexer votes no.
Thank you. The final tally on Amendment B is 10 voting yea, 27 voting nay, 0 abstain, and 4 absent.
That amendment fails as well. Is there further discussion on the underlying bill? Is there further discussion on the underlying bill? If not, Madam Administrator.
Chair,
Representative O'Day.
just a quick question to the good chair. Did I understand that it's his understanding that under Connecticut, minors are not allowed to have breast removal surgery as part of gender affirming care?
Representative, what I said is I'm not clear whether they can or they cannot. I've been sitting here trying to do some research on that question, and I found at least some media reporting that suggests in Connecticut, individuals under a certain age are not allowed to engage in gender-affirming surgeries, whether that's by operation of law or regulation or hospital practices. I cannot tell you. Like I said, I believe that's more properly the purview of the Public Health Committee as opposed to the purview of this committee.
Thank you, Mr. Chair. My understanding is there was some testimony that minors were allowed and did in fact have breast removal surgery as part of their gender affirming care. I hope I'm wrong. I hope the good chair is right. But I'm still going to vote no on this bill because I don't think we should be shielding doctors or hospitals who are performing these surgeries that are not recommended by the AMA or the American Society of Plastic Surgeons on minors. So thank you very much, Mr. Chair. I appreciate it.
Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 295 to JFS it to the floor with LCO 3529. Winfield,
Winfield, any affirmative?
Staffstrom,
Yes.
Flexer, Gadkar Wilcox, Fazino,
Fazino votes yes.
Kissel, Fishbein, Blumenthal, Brown,
Brown votes yes.
Cabrera,
Yes.
Callahan, Ciccarella, DiCaprio,
No.
Delaney,
Delaney, yes.
Dillon,
Dillon votes yes.
Peck,
Yes.
Dubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist,
Crest votes yes.
Godfrey, Howard,
Yes.
Jacobson,
Yes.
Johnson,
Mhm.
Khan,
Yes.
Lamarck Muir,
Yes.
Lesser, Marr,
Senator Marr votes yes.
Miller,
Yes.
O'Day,
O'Day votes no.
Osborne,
Osborne votes yes.
Havelock D'Amato, Perillo, Quinn,
Yes.
Rahman,
Yes.
Roberts,
Yes.
Rutigliano,
No.
Sims,
Sims, yes.
Veach,
Beach is a no.
Walker,
Yes.
Wilson,
Thank you. All right, item number 7 on our agenda, Senate Bill number 398, an act concerning the Board of Pardons and Paroles. The motion will be a JF. Motion from Senator Winfield, second from Senator Kissel. This bill simply eliminates the statutorily prescribed amount of pay for a part-time board member and allows the Board of Pardons and Paroles to set that within their available budget. Let me emphasize that for some folks on our nonpartisan staff, it's within their available budget. Is there discussion or comment on this? If not, Representative Fishbein?
Mr. Chairman, I make a motion, we move item number 7, SB 398, an act concerning the Board of Pardons and Paroles to the consent calendar.
Without objection, that is so ordered. Next will be Senate Bill number 399, an act prohibiting separate areas for exercise and concerning the disposition of cases before the Commission on Human Rights and Opportunities. The motion will be a JFS, LCO number 3521. Is there a motion? Motion by Senator Winfield, second by Senator Kissel. I will just note briefly that the JFS language removes the original section 1 of this bill, which was the provision related to gyms and health clubs. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I was prepared to support the bill as drafted before the committee. I very much appreciate the exchange with the commission leadership. I'm disappointed, though, that Section 1 is being removed. You know, I think that women, in particular, you know, survivors of rape, domestic violence, you know, other heinous things that are perpetrated upon them should be able to have their safe space, especially at a health club or gym. You know, I've found that exercise has an element of help to individuals that are, you know, depressed as a result of something they've been through, and to know that they can go to a safe space, I think, is of help. And that's what Section 1, I think, at least that was the intent of it. To remove it prevents providers from being able to provide that safe space for fear of being accused of being discriminatory. I just don't think that's the public policy that we should be setting in this state, but unfortunately the powers that be, I guess, would prefer those individuals to be in the state that they are. So I don't support that, and therefore I find myself having to vote against the entirety of the bill. So thank you, Mr. Chairman.
Further discussion on the bill, Representative Pavlik-Tomato.
Thank you, Mr. Chair. I too have the same disappointment as my ranking member. I know the language had to be worked on, but we did hear testimony from an individual who had a business, had these classes, has a gentleman who comes in really just to harass the other customers, and now she's being punished. I don't understand. I think the constant, I feel, attacks on women in this building, to me, it's upsetting, and why women can't have these spaces during times of pregnancy, especially during times of when there's trauma. For me, I thought it was a bill with purpose, a very good bill, a bill that addresses a current situation going on in this state, that really clarifies and maybe even has the potential to narrow what the court case decided on previously. So for that reason, I will be voting against this bill. Thank you, Mr. Chair.
Further discussion or comment on this, Senator Winfield?
Thank you, Mr. Chair. And in respect to the comments of my colleagues, I think, despite the language used, the leadership of the committee does understand the issue in front of us, does take it very seriously. What was presented to us has issues beyond what appears just on the surface of this bill, and we hadn't figured out how to deal with those issues yet. So it is not, as may have been represented, that the powers that be, if you will, want to just leave this situation in place. But as we do oftentimes here, we're removing the language that we haven't figured out how to work yet, and the session is not over. Thank you, Mr. Chair.
Senator Lesser.
Yes, thank you. And this concerns a constituent of mine, and this is an issue that I'm very actively engaged in, and I appreciate having the opportunity to speak to the chairs about it. I think this is, the chair mentioned, the Chairman Winfield mentioned, still a work in progress, and hoping we can get to a good place that will resolve this issue, because it's obviously disturbing. It's
Further discussion on this? Further discussion? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 399 to JFS it to the floor with LCO 3521. Winfield.
Winfield in the affirmative.
Statstrom.
Yes.
Flexer. Gadkar Wilcox. Fazino.
Fazino votes yes.
Kissel. Yes. Fishbein. No. Blumenthal. Brown.
Brown votes yes.
Cabrera, Callahan, Chicarella, DiCaprio,
DiCaprio, no.
Delaney,
Delaney, yes.
Dillon,
Dillon, yes.
Doucette,
Yes.
Dubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Howard,
No.
Jacobson,
Yes.
Johnson, Khan,
Yes.
Lamarck Muir,
Yes.
Lesser, Marr,
Mara votes yes.
Miller,
Miller votes yes.
Day, Osborne,
Yes.
Pavlik Tomato, O'Day,
Repo Day votes no.
thank you, Perillo, Quinn,
Yes.
Rahman, Rahman,
Yes.
Roberts,
Yes.
Vertigliano,
No.
Sims, Veach,
Veach votes no.
Walker,
Walker votes yes.
Wilson,
Lesser votes yes.
thank you.
All right. Powers that be will now turn to Senate Bill number 10. Sorry, item number 10 on our agenda, which is Senate Bill number 474, an act concerning the provision of annual training to a person appointed as a conservator in a probate court proceeding. The motion will be a JF. Motion from Senator Kissel, second from Representative Fishbein, who apparently does not consider himself to be a power that be. Is there discussion on the bill? Is there discussion? If not, Representative Fishbein, let me turn to you and see if you'd like to make a motion, sir.
Me not being a power that be, merely a power of fly. Think deep about that one. I make a motion, Mr. Chairman, that we move item number 10, SB 474, an act concerning the provision of annual training to a person appointed as a conservator in a probate court proceeding to the consent calendar.
Seeing no objection, that's so ordered. Item number 11, Senate Bill number 483, an act establishing the crime of digital forgery. The motion will be a JF.
So moved.
Motion from Senator Kissel, second from Senator Winfield. I will entertain an amendment, which will be made in line 26 of the bill. We will strike the word offense and insert defense in lieu thereof. Is there a motion? Motion from Representative Fishbein, second from Senator Kissel. Discussion on the amendment. Discussion on the amendment. If not, let me try your minds. All those in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. The amendment is adopted. Discussion on the underlying bill. Seeing no discussion, Representative Fishbein.
Mr. Chairman, I make a motion that we move item number 11, an act establishing the crime of digital forgery to the consent calendar.
Without objection, so ordered. Number 12, Senate Bill number 507, an act concerning the Correction Advisory Committee. The motion will be a JF.
So moved.
Second.
Motion from Senator Kissel, second from Representative Fishbein. Discussion. Seeing none. Rep. Fishbein.
Mr. Chairman, I make a motion we move item number 12, SB 507, an act concerning the Correction Advisory Committee to the consent calendar.
Is there objection to placing the item on consent? Is there objection? Seeing none, that's ordered. 13. I'll turn it over to Senator Winfield.
Number 13, House Bill number 5308, an act concerning post-conviction DNA. The motion will be a JF. Is there?
So moved.
Second.
Moved by Senator Kissel, second, I think slightly by Representative Fishbein. Is there discussion? Is there discussion? If not, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I make a motion we move item number 13, HB 5308, an act concerning post-conviction DNA testing To the consent calendar.
Is there objection to moving this item to the consent calendar? Is there objection? Seeing none, this item will be placed on the consent calendar. Number 14, House Bill number 5312, an act establishing a civil action for the Office of the Attorney General and a private right of action for victims of unlawful dissemination of a synthetically created intimate image.
So moved.
Well, hold on a second.
Okay.
There's JFS language, right? And it's LCO. I don't have, 1 second, I don't have it right in front of me.
Get ready to move.
LCO 3557. Is there a motion?
So moved.
Second.
Moved by Senator Kissel, seconded by Representative Fishbone. Is there discussion? Representative Fishbone.
Thank you, Mr. Chairman. Just briefly, anytime you see a bill that has Attorney General, civil action, all that stuff in it, I'm usually opposed. In all candor, I do thank the Office of the Attorney General for working a lot with me on this bill, so that it is in a place that I hope it becomes law. So, thank you, Mr. Chairman.
Thank you, Representative Fishbone. Further discussion on the bill? Seeing none. Representative Fishbone.
Thank you, Mr. Chairman. Mr. Chairman, I make a motion we move item number 14, HB 5312, an act establishing a civil action for the Office of the Attorney General and a private right of action for victims of unlawful dissemination of a synthetically created intimate image to the consent calendar.
Thank you, Representative Fishbone. Is there a second?
Second.
Seconded by Senator Kissel. Is there objection to placing this item on consent? Is there objection to placing this item on consent? Seeing none, this item will be placed on consent. All right, number 15, House Bill number 5313, an act concerning the development and implementation of a plan for the use of uniform statewide case identification codes in domestic violence cases.
So moved.
It's a JFS LCO 3. I'll come back to you. It's a LCO 3479. Is there a motion?
So moved.
Moved by Senator Kissel, second by Representative Stastrom. Is there discussion? Representative Fishbone.
Mr. Chairman,
God bless you.
I'm going to make a motion. I believe this is a friendly amendment to strike starting at line 30 through the end of in line 37, the word plan is the first word. To strike that language. So moved.
It was moved by Representative Fishbone and seconded by Representative Stastrom. Is there discussion on the amendment?
If I could just explain why.
Yep, you may proceed.
Thank you. So there was 2 dates that appeared in the language. It had an interim status report date, and then the report date, and I think it'd be cumbersome for a status to, it's going on, right? That's the status. So all this amendment does is it removes that interim reporting, and the report would be due July 1, 2027, and that's not changed by the amendment. So thank you, Mr. Chairman. Yes, thank you.
Thank you, Representative Fishbone. Representative Stastrom?
I consider it to be a friendly amendment, Mr. Chair.
Thank you. Further discussion on the amendment? Further discussion? If not, all in favor signify by saying aye.
Aye.
Opposed? The ayes have it. Further on the bill? Further on the bill? If not,
I'm good. Yeah. Oh, okay. Well, you didn't recognize me.
You're not a power that he.
That's right.
Representative Fishbone.
Thank you, Mr. Chairman. Mr. Chairman, I make a motion that we move item number 15, a HB 5313, an act concerning the development and implementation of a plan for the use of uniform statewide case identification codes in domestic violence cases to the consent calendar.
Thank you, Representative Fishbone. Is there objection to placing this item on the consent calendar. Objection to placing this item on the consent calendar. See none? This item will be placed on the consent calendar. House, number 16, House Bill number 5431, an act concerning cooperative corporations. Is there a motion?
So moved.
Second.
Moved by Senator Kissel and seconded by Representative Fishbein. Is there discussion? Is there discussion? Seeing none. Representative Fishbein?
Thank you, Mr. Chairman. Mr. Chairman, I make a motion we move item number 16, HB 5431, an act considering cooperative corporations to the consent calendar.
Thank you, Representative Fishbein. Is there objection to placing this item on consent? Is there objection to placing this item on consent? See none. This item will be placed on the consent calendar. Okay. Number 17, House Bill number 5432, an act concerning the receipt of fees by a party to a civil action affecting title to real property. Is there moved by Senator Kissel? Second.
Second.
Second by Representative Fishbein. Is there discussion of this item? Is there discussion of this item?
You can go. You can go.
Representative Staffstrom.
Thank you, Mr. Chair. Mr. Chair, I move House Bill number 5432 to consent calendar.
Is there objection to placing this item on consent? Is there objection to placing this item on consent? If not, this item will be placed on consent. Representative Staffstrom.
Mr. Chair, I would make a motion that we remove
507.
Senate Bill 507, which was item number 12 on our agenda, from the consent calendar.
The item will be removed from the consent calendar. And Madam Administrator, when you are ready, if you could call the roll on Senate Bill number 507, which is number 12 on our agenda.
Roll call vote on Senate Bill 507 to JF it to the floor. Winfield.
Winfield in the affirmative.
Staffstrom.
Yes.
Flexer. Gadkar Wilcox. Fazino.
Fazino votes yes.
Kissel.
Yes.
Fishbein.
Yes.
Blumenthal. Brown.
Brown votes yes.
Cabrera. Callahan. Ciccarella.
Ciccarella votes yes.
DiCaprio.
Yes.
Delaney.
Delaney votes yes.
Dillon.
Dillon votes yes.
Doucette.
Yes.
Dubitsky.
No.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey.
Yes.
Howard. Jacobson.
Yes.
Johnson. Khan.
Yes.
Mark Newer.
Yes.
Lesser. Marr.
Mar votes yes.
Miller.
Chris, you want to?
Miller votes yes.
Oh, thank you. O'Day.
O'Day votes yes.
Osborne.
Osborne votes yes.
Havelock D'Amato. Perillo. Quinn.
Yes.
Rahman.
Yes.
Roberts.
Yes.
Vertigliano.
Yes.
Sims.
Sims in the affirmative.
Beach is a yes.
Walker.
Yes.
Wilson. Thank you.
Thank you, Madam Administrator. All right. Number 18 on our agenda, which is House Bill number 5449. There's going to be a JFS for it, which is LCO 3559. It's an act concerning automated license plate reader systems. Representative Staffstrom. Oh, is there a motion?
So moved.
Second.
Moved by Senator Kissel, seconded by Representative Fishbein. Now, Representative Staffstrom.
Thank you, Mr. Chair. Mr. Chair, I think 5449 is one of the, I would say, more important bills on our agenda today. I think this is an issue which I think the committee on, I think I'd say both sides of the aisle, really took seriously as we heard testimony during the public hearing on the proliferation of these cameras that are being placed around the state to capture license plate data, and the real growing concern of what is happening to that data, how long is it retained for, is there uniformity from one department to the next, what are the parameters by which that data will be destroyed, who can access it, et cetera. There were a number of moving parts on that, and I know we heard testimony that the Post Council has engaged in their own policy, but frankly, I think it's important that the legislature weigh in and put a marker down that balances the public safety benefit that can come from these license plate readers and the way in which they can be used to solve crime, but also the manner in which we are protecting folks' civil liberties and making sure that they are not being harassed or targeted for going about lawful activities in our state, and that they do have a degree of privacy. So the underlying bill, I believe, is an important one. The JFS language which we have is a compilation of a significant amount of work that has happened since the public hearing on this bill. I want to particularly thank the Department of Emergency Services and Public Protection, as well as the ACLU, and other stakeholders, including the judicial branch, for coming to the table to work through some of the concerns. Some of the concerns that I believe are addressed in the JFS language is a concern we heard from DOT involving their work zone speed cameras. We also attempted to address concerns that were raised by the police chiefs related to the National Crime Information Center database and the database for missing and exploited children. We also worked on addressing concerns involving multi-jurisdictional task forces to make sure that certain federal agents, mainly FBI agents, have access to the data where necessary, but that is not being shared for immigration purposes outside of the state of Connecticut. And I would say, I think the most significant change that was made is relating to the retention period. The latest draft of this bill, I think, strikes the right balance, which is that the data can be retained for a maximum of 30 days, which is the period that the Post Council has called for in their policy. But after 7 days, which was the original language of the bill, law enforcement would need a warrant in order to access the information. So while it would still exist on the system for a maximum of 30 days and could be available to be used as part of an investigation, after that first initial 7-day period, you would have to get a judicial warrant to access the info, which I think puts in place that right balance between what the proponents of this wanted on public safety, as well as making sure that we are not letting this information just willy-nilly out there in the ether. Thank you, Mr. Chair.
Thank you, Representative. Senator Kissel.
Thank you very much, Chairman Winfield. I'd like to thank Chairman Staffstrom for his willingness to compromise on the bill and work with all the various parties. There's a lot of moving parts, as he indicated, and I actually at the outset want to say it's my understanding there's other bills percolating this building coming out of other committees, but I really hope that the one that comes out of this committee is the one that crosses the finish line. And to my mind, that final change of the retention period going to 30 days, that law enforcement has free and ample use of this information up until 7 days, and then would need a warrant thereafter, is critically important. And the example that I would throw out there is many of us are familiar with that kidnapped woman or whatever happened to that woman out in Arizona, that she's a missing grandmother that's been followed in the news. And one of the things that they were looking into was the doorbell cam. And it took them a while to get the pictures from that doorbell cam. So the proposition that I put out there was that, let's say it would take over a week to get to the point where you access the doorbell camera film or visual, and let's say you caught part of a license plate in the background. Now, all of a sudden, in an ongoing investigation, you realize that you need that information on that license plate. What this bill with the new language would do is, okay, it's after 7 days, you can still go to a court based on your ongoing investigation and get a warrant to get that data. But for most cases, if you don't know what you're looking for after 7 days, there really is not just an open season fishing expedition that would be allowed. And again, I agreed with the sentiments offered by our friends over in the Civil Liberties Union that came and testified. For my libertarian friends, I think they have an appreciation for people's privacy rights as well. And so we want to protect people's privacy rights in our free and open society because there is so much technology out there, and this is a difficult area. In years past, I was on program review and investigations, and many a time we tried to get our arms around drones. When could they be used by law enforcement, and when would they be forbidden? You just can't have them hovering around people's homes, peeking into windows. That would be inappropriate and terribly intrusive and compromising our freedom and our liberty and our privacy. That issue is still to be decided. I think we haven't nailed down the drone issue. But on this issue, with the advent of technology and the ability to access this information from license plates using license plate readers, which just only recently has come to my attention, being located in various places in Enfield and north central Connecticut. They're out there, folks of Connecticut, and we just want to make sure that law enforcement uses it in critical matters within a week. And if there's a further investigation, it can be retained up to 30 days. But after that, it should be extinguished and no longer available because it's just waiting to be abused or inadvertently leaked like so much of our databases do in this time and age. So I want to thank, again, Chairman Staffstrom, the advocates on both sides of this issue, Chairman Winfield, and my friend and colleague, Representative Fishbein. I think we've reached that happy compromise, and I really hope this bill crosses the finish line. Thank you, Mr. Chair.
Thank you, Senator Kissel. Comment or question from other members of the committee? Comment or question from other committee members? If not, Representative Dubisky.
Thank you, Mr. Chairman. I appreciate the Senate ranking members feeling that this bill is a good compromise. Frankly, I don't think it goes far enough. I think that I have always been opposed to license plate readers. I still am. I think they are a gross infringement on the rights of the people of this state. You can't have a police officer following people around without some reasonable suspicion that they've committed a crime. Well, this does that very thing electronically. Now, I understand the purpose of this bill is to limit to some extent the access to that data, but the data exists nonetheless. I will support this bill because it does, to some extent, limit the use of these readers, but I don't think it goes far enough. I frankly think we should ban them all. I understand that they are useful in law enforcement. Great. There's a lot of things would be useful in law enforcement that violate people's rights. This is one of them. Law enforcement has certain limitations on the tools that they can use and the ways that they can surveil people. I think having automated license plate readers all over the state, which can easily just follow people around wherever they go in the state goes beyond what I think law enforcement should be empowered to do. So I will support this because it does essentially put some limits in it, but I think it should go further. Thank you, Mr. Chairman.
Thank you, Representative. Further comment on the bill? Further comment on the bill? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5449 to JFS it to the floor with LCO 3559. Winfield,
Winfield, in the affirmative.
Staffstrom, Flexer, Gadkar Wilcox, Fazino,
Fazino votes yes.
Kissel,
Yes.
Fishbein, Blumenthal, Brown,
Brown votes yes.
Cabrera, Callahan, Ciccarella,
Chicarella votes no.
DiCaprio,
Caprio votes no.
Delaney,
Delaney, yes.
Dillon,
Dillon votes yes.
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Howard,
No.
Jacobson,
Yes.
Johnson, Khan,
Yes.
Lamarck Muir,
Yes.
Lesser, Marr,
Senator Marr votes yes.
Miller,
Miller, yes.
O'Day,
Day, no.
Osborne,
Yes.
Pavlik D'Amato, Perillo, Quinn,
Yes.
Rahman,
Yes.
Roberts,
Affirmative.
Retigliano,
No.
Sims,
Yes.
Veach,
No.
Walker, Wilson,
Okay. As a reminder, votes will be held open until 4 p.m. The committee will return tomorrow to continue the work we're doing. Same bad time, same bad channel.
Are we voting on the consent calendar?
Yeah, we gotta do the consent calendar. Yeah. All right. So, Madam Administrator, when you are ready, please read the items on the consent calendar and follow that up with a vote.
consent calendar consisting of Senate Bill 89 with Amendment A. I should say JFS to the floor with Amendment A. Senate Bill 290, JF to the floor. Senate Bill 398, JF to the floor. Senate Bill 474, JF to the floor. Senate Bill 483, JFS to the floor with Amendment A. House Bill 5308, JF to the floor. House Bill 5312, JFS to the floor with LCO 3557. House Bill 5313, JFS to the floor with LCO 3479 in Amendment A. House Bill 5431, JF to the floor, and House Bill 5432, JF to the floor.
Thank you. Would you please call the roll?
Winfield,
Winfield in the affirmative.
Staffstrom, Flexer, Gadkar Wilcox, Fazino,
Fazino votes yes.
Kissel, Fishbein, Blumenthal, Brown,
Brown votes yes.
Cabrera,
Yes.
Callahan, Ciccarella,
Chicarella votes yes.
DiCaprio,
Yes.
Delaney,
Delaney in the affirmative.
Dillon,
Dillon votes yes.
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Howard, Jacobson,
Yes.
Johnson, Khan,
Yes.
Lamarck Muir,
Yes.
Lesser, Marr,
Yes.
Miller, O'Day,
That's a yes.
Day votes yes.
Senator Lesser,
Lesser, yes.
Osborne,
Yes.
Pavlik D'Amato, Perillo, Quinn, Rahman,
Yes.
Roberts,
Yes.
Retigliano,
Yes.
Sims, Veach,
Yes.
Walker, Wilson,
All right, now the votes will stay open till 4 p.m.
Madam Clerk, whenever you're ready, if I could vote on whatever I missed, please.
Senator Chicarelli, can you hear me okay?
Yes, I can hear you.
Okay, excellent. I have you for, the okay, for Senate Bill 90.
I'm sorry, what was the number?
Second. It's going to be for 295. So item number 5.
Okay, 295. I vote, no.
Okay. And then 399.
And I vote no as well.
That's it, right? You're all set. That's it.
Thank you so much.
Thank you.
Have a great day.
You too. Oh. Sorry, Senator Lester, can you hear me okay?
No, I can't.
Okay, excellent. I have you for consent. So starting at the top, Senate Bill 90.
Senate Bill 90 is a yes.
Okay. For Senate Bill 91.
Yes,
Okay. For 295.
is a yes.
That is a yes. Okay. For 397.
Yes.
For 399, I have you as a yes. 507, how'd you like to vote?
Yes. I don't know. What is that one?
507. That is, that's in line with the chairs.
Okay.
And then 5449, the last one.
And then to release the.
Yes.
Okay, you're all set. Thank you.
Thank you.
Give me 1 second, Senator. Okay. Senator Mark. All right. So I have you for consent already, so you're all set for that. So going back to the other, for the roll calls. For Senate Bill 90, how would you like to vote?
Yes.
Okay. For 91.
Yes.
For 295, I've got you. 397, how'd you like to vote?
Yes.
Okay. For that one. You're right. You're all set. Thank you so much.
Okay, great. Thank you, Madam Administrator.
Thank you. For Senator Gaston.
Yes, just wanted to make sure I didn't miss any votes. I don't believe I did.
Just quick. And let me just check the consent. 1 second. All right, Senator, you're all set.
Thank you.
You're welcome. Representative Gilchrist.
Hi, how are you?
Good, and yourself?
Good.
Okay, so for Senate Bill 90.
Yes.
91.
Yes.
205 for 397.
Yes.
399.
Yes.
507.
Yes.
5449.
Yes.
And in the consent, I don't know if I missed you for that. How'd you like to vote?
I'd like to vote yes.
Okay, excellent. You're all set. Thank you.
Thank you. Have a great day.
You too. Representative Delaney.
Yes, Madam Administrator, I just wanted to double and triple check that I hadn't missed any votes.
No, I think you're okay. We'll double check right now. Yes, you're all set.
Thank you, Madam Administrator. Have a good day.
You too. Representative Dillon.
That's right.
Can you hear me okay?
Thank you. I want to make sure all of my votes are recorded. I believe that one of them was not.
So Senate Bill 90, I'm missing from you. How would you like to vote?
Vote yes.
Okay, let me just double check. Okay, you're otherwise all set. Yep, thank you.
Thank you. Thank you for your work.
Thank you. Take care. Representative Walker.
Hello. Oh, hello.
Hi, Senator. How are you?
I'm good. How are you, busy lady?
We're getting there. We're getting there.
Yeah.
We're doing so great. Okay, so consent calendar, let me get that out of the way.
Yeah, let me have the numbers. That's
Yeah, of
why it
course.
went off because I didn't know exactly which one. So
That's
it's
okay. We
number
moved a little.
one.
So number 1 is on consent.
Okay.
Number 4 is on consent.
All right.
Number 7 is on consent. Number 10 is on consent.
Mm-hmm.
Number 11 is on consent.
Mm-hmm.
Number 13 is on consent. Number 14 is on consent.
Mm-hmm.
Number 15,
Mm-hmm.
and then number 16 and number 17.
I vote yes.
All right, great. So back to the others, starting at the top, Senate Bill 90, number 2.
It's a government bill. Yes.
Okay. Senate Bill 91, number 3.
Yes.
Okay. 295, I've got you already. 397, which is number 6.
Yes.
Okay. 399. I've already got you.
They have
Hang
me.
on, I've got
Mhm.
you. And I've got you for 507, and then you're all set. And then 5449. You're good to go.
What about number 9?
I'm sorry, number 9 we skipped. We
You
held it.
skipped. Okay, I just wanted
Yep.
to make sure.
Sorry
Okay,
about
thank
that.
you.
Yeah. Yeah, you're
Nope,
welcome.
that's okay. Thank you.
You
Thank you
got
for
it.
your patience and all the work you do.
Yeah, anytime, please. I'll see you in the morning.
Bless you. Okay, bye.
Hi, Representative, can you hear me okay?
Yeah, they're all done.
Excellent.
They're all done, I assume, Kirsten.
Yeah.
All right, sorry, I had to run out to go to another meeting. I'm sitting in a town hall in my district at the moment.
No, no, you're totally fine. Everybody's in 5 different places at once, as always.
Yeah.
Okay, so do you want me to just tell you what's on consent? Do you want to just go, like, do you want to vote on the consent?
Let's do consent and then we can, I know there's probably 3 or 4 others I gotta do.
Okay, so how do you want to vote on the consent? Do you want to know what it is or just vote?
No, I'm well aware.
Okay.
I'm a yes on consent.
All right, great. And then I need you for, let's see, have you for Lindsay? 295. How would you like to vote?
Do you remember what number, Bill, on the agenda?
295 is number 5.
Number 5. I think I need glasses or I just squint. I'm a no, Kirsten.
It's hard these days. 397. I've got, so 399, which is number 8.
No.
Okay. Let's see, for 507, how'd you like to vote for 507, which is number 12.
Well, I'm a yes.
Okay, and then 5449.
Was that number 18?
It is number 18. I'm sorry.
I'm a no.
Okay, that's it. You're all set.
Thank you. See you soon.
Thank you. Take care. See you tomorrow.
Bye-bye.
Hello.
Hi, Representative Sims.
How you doing?
Good, and yourself?
I'm good. Just
Okay,
needed to,
so,
I know I missed some votes.
yep, real quick. So for Senate Bill 90, how would you like to vote?
In the affirmative.
Okay, and then the other one is for Senate Bill 399.
In the affirmative.
Okay, and you're all set. Thank you so much.
Awesome. Take care.
You too.
Alrighty.
One sec, sorry.
That's okay.
You're on mute.
Can you hear me okay?
Yes, thank you, Madam Administrator.
Okay, for the consent calendar, how would you like to vote?
Yes. Blumenthal votes yes.
Okay, for Senate Bill 90,
Blumenthal votes yes.
for Senate Bill 91,
Blumenthal votes yes.
Senate Bill 295,
Blumenthal votes yes.
Senate Bill 397,
Blumenthal votes yes.
Senate Bill 399,
Blumenthal votes yes.
Senate Bill 507,
Blumenthal votes yes.
and then for House Bill 5449.
Blumenthal votes yes. And sorry, let me just check the agenda one more time.
Yeah.
Make sure I'm remembering everything correctly.
Of course.
Oops. I should be all good. Thank you, Madam Administrator.
All right, all set. Thank you so much, Representative.
Thank you.
Senator Gadkar Wilcox, how are you?
Hey there, good. How are you?
Good.
See you, Matt.
How would you like to, on the consent calendar, how would you like to vote?
Yeah, can you just tell me what items went on the consent calendar?
absolutely.
Did
Yeah,
I
we'll
vote
start
on
from the
everything
top.
that wasn't? Did everything else go on consent? I don't know if I missed a vote in the morning too.
I missed your vote, yes, on Senate Bill 295, which is number 5.
Oh, yes, that's a yes.
Okay, and then, but I had one more. One second. I need you for Senate Bill 399, which is number 8.
Yes, and I just want to make sure the chair, Senate chair, was yes on both of those.
He was, yep, for
Yeah,
both.
okay, great.
And then I need you for 507.
507.
Number 12.
Correction, right? Yes.
Okay, and 5449, which is the last number 18.
544. Yes.
Okay. All right, and then I can tell you what on consent. On consent was item number 1. It was number 4. It was number 7. It was number 10, number 11, 13, 14, 15, 16, and 17. Those are all on.
Okay. Yes, and I'm a yes on the consent calendar.
Okay, excellent. Perfect. That's everything.
Great. Thank you so much.
Take care.
Have a great day. Bye.
You too.